What rights do H-1B workers have in the U.S.? Imagine this. You've moved to the United States on an H-1B visa. You've left your home country, friends, routine, and maybe even your family behind. You're here because an employer offered you a professional job, maybe in tech, engineering, research, finance, or healthcare. The H-1B is supposed to give skilled foreign workers opportunities while helping U.S. employers fill specialized roles. But once you start working, questions begin to appear. What if your employer cuts your pay? What if they change your job duties? What if the workplace isn't safe? What if they threaten your immigration status if you speak up? Millions of workers assume that having a work visa means they have no power, that the employer has complete control. That is not true. In this video, we're going to break down the rights H-1B workers have under U.S. labor law, immigration law, and workplace protection law, and what you can do if your employer abuses the system. Your immigration status does not cancel your worker rights. Let's start with something many H-1B workers never hear clearly. The H-1B visa does not make you the property of your employer. You are still protected by the same labor laws that protect U.S. citizens and permanent residents. The law does not say workers with papers get rights and workers without papers don't. Workplace rights are tied to the fact that you are working, not to your nationality. H-1B workers are protected under the Immigration and Nationality Act, INA, the Fair Labor Standards Act, FLSA, for wages and overtime, OSHA, Regulations for Workplace Safety, Title VII of the Civil Rights Act, which prohibits discrimination and harassment, the National Labor Relations Act, NLRA, which protects the right to discuss wages and conditions. Having a work visa does not mean you must silently accept mistreatment. It means the employer has legal obligations, and the government can enforce them. Your employer must pay you the wage. They promised every H-1B employer must file a Labor Condition Application, LCA, with the U.S. Department of Labor. In the LCA, the employer promises the government that they will pay you either the actual wage paid to similar employees in the company, or the prevailing wage for the occupation in that geographic area, whichever is higher. This is a legal requirement, not optional, not negotiable, and not something your employer can explain away with excuses. If your employer tries to pay you less than what is listed, delay your pay, reduce your hours without updating paperwork, put you on the bench without pay. These are violations. The Department of Labor can require the employer to pay back wages, penalties, and even bar them from sponsoring visas in the future. Example: a software engineer on an H-1B is told business is slow and she will not be paid for the next 2 weeks until new projects come in. That is illegal. Even if you are benched, your employer must keep paying your required wage. Your job role and working conditions must match what was filed. The job title, responsibilities, work location, and wage level listed on your H-1B petition and LCA are not suggestions. They are legally binding conditions. If your employer moves you to a different location, assigns you completely different job duties, cuts hours, transfers you into a role below your original skill level, they may be violating immigration law unless they amend the petition. This means you are not required to silently accept being downgraded or used as cheap labor. The visa was issued because your job requires specialized skills. The employer must treat the job accordingly. You have the right to a safe workplace. OSHA applies to H-1B workers the same as everyone else. You have the right to proper equipment, safety training, protection from danger, Report unsafe conditions without retaliation. If your workplace is unsafe, you can file a report confidentially. OSHA does not report immigration status. Example: if a biomedical lab worker on an H-1B is forced to handle hazardous chemicals without training or protective gear, that is an OSHA violation, regardless of visa status. You have protection against harassment and discrimination. Title 7 makes it illegal for employers to discriminate based on race, religion, national origin, or sex, and that includes immigration-related harassment. If a manager says things like, "You're lucky to even have a job here," "We can replace you with someone cheaper from your country," "Your visa means you do whatever we say." These statements can be evidence of harassment and coercion. You are also protected if you experience sexual harassment, hostile work environment, or retaliation for speaking up. You have the right to change employers, visa portability. A lot of H-1B workers believe they are trapped with one employer, but the law allows H-1B portability. You can change employers as soon as your new employer files a new H-1B petition. You do not need to wait for approval. Filing is enough to begin working. This means you do not have to endure underpayment, abuse, discrimination, unsafe conditions. Just because you fear losing your visa, you can leave, and you have 60 days of grace period to find a new employer after separation. This grace period is critical. It means you have time. You are not powerless. You can report violations without losing status. If your employer violates wage laws, threatens you, withholds pay, or abuses the visa system, you can report them to the Department of Labor without risking your H-1B status. The government's position is clear. The worker is not at fault for an employer's violation. In some cases, workers who experience severe abuse or coercion may qualify for U visas for victims of threats or certain crimes, T visas for labor trafficking situations, deferred action protection during investigations. This means speaking up may protect your immigration future, not harm it. The human reality of H-1B work. H-1B workers often feel isolated, far from family, tied to a job, worried that one wrong move could uproot their lives. Employers who exploit this fear do so because they assume workers don't know the law. But the truth is stronger than fear. H-1B workers have real rights. Those rights exist to protect not only the worker, but the fairness of the entire labor market. You are not powerless. You are not replaceable. You are someone whose work has value, and the law recognizes that. So, what rights do H-1B workers have in the U.S.? The answer is, more than most people realize. You are protected by wage laws, safety laws, anti-discrimination rules, and retaliation protections. Your employer must pay you the wage they promised. They must follow the job terms listed in your petition. They cannot bench you without pay. They cannot threaten your visa to silence you. And you can change employers if necessary. The bottom line, you are not tied to your employer. They are tied to the law. If this video helped empower you, share it with coworkers or friends. Knowledge breaks fear, and your rights matter, no matter where you were born.